Oftentimes, parties will ask whether or not their matter is contested or not. So, what is a contested probate matter? A lot of times, it's very common that you'll have parties that don't agree on certain aspects of the administration, whether it's who should be in charge or how property should be distributed or dispersed amongst the heirs. That's simply a disagreement. A matter becomes contested when a petition is filed with the court to probate a will or for a person to become administrator over an estate. And one of the heirs, in response to that petition, officially filed what's called a caveat. That's just a fancy word for an objection. At that moment, the matter has now become contested. It gets put on a separate track in the probate court. The time frame will include 6 months of what's called discovery. So from the date that the objection or the caveat is filed, the parties will have 6 months of formally exchanging information amongst themselves. Those may be written questions called interrogatories, or may be requests for production of certain documents, such as bank statements or the decedent's medical records. The parties will also be able to submit non-party requests during this period of time to financial institutions such as banks or to medical healthcare providers, whatever is needed to help them prove their case in this contested probate matter. So who are the parties who have standing or have the ability to contest a petition once it's filed? So if there's a will contest, you have to be a direct heir in order to contest the will. The philosophy behind that is if the will is proven to be invalid, then the property is going to pass pursuant to Georgia law, which is to the next heirs. So if you're not an heir to receive property in the event the will is set aside, then you don't have standing or you don't have an interest enough in the matter to be able to file a caveat or an objection. As far as petitions for letters of administration, any of the heirs can file an objection to the petition to either have someone else appointed as the administrator or to have the county administrator appointed. Creditors can also file objections to petitions for letters of administration. So they have an interest in the estate to make sure that the estate assets are preserved and that the creditors will be paid from those estate assets. Therefore, the law allows them to have a say-so in who will be appointed the administrator of the estate. As far as will disputes go, there are certain grounds that are available for a person to contest the will. First is the formalities of the will, whether or not the will has the signature of the decedent and 2 witnesses to that signature. Another requirement or formality that we normally see is a self-proving affidavit. The self-proving affidavit has to be signed by the 2 witnesses to the will and also notarized. So those documents will be looked at to make sure, first and foremost, that we have a valid will. Sometimes I'll see a will and maybe the notary didn't include the date when they signed the document. That's not an official notarial act. So therefore, that invalidates the self-proving affidavit, which means that in order to probate the will, you now have to track down the 2 witnesses and have them fill out interrogatories attesting to the fact that the will is, in fact, the representation of the last wishes of the decedent. And sometimes you can't find the witnesses, so that presents a big problem to those people that are presenting the will for probate. Another common ground or essential fact we have to look at when deciding whether a will is valid or not is testamentary capacity. And that's the testator at the time the will was signed had the capacity to understand who his or her heirs were and to understand the nature of their property as well. So we see that often when later in life, when folks are suffering from dementia or in situations where folks are just old and lonely and they are subjected to the undue influence or the coercion of a healthcare provider or someone that the testator is relying on a daily basis to make sure that they're receiving care or make sure that their finances and bills and such are being paid. And that brings us to probably the most popular ground that I do see. It is the undue influence. So those are typically have red flags with undue influence in situations where a will was done very closely to the time or the date of death of the decedent. And so those are wills that are done when a person's in the hospital the will leaves all the property to someone other than the natural heirs. And sometimes the property is left to an unnatural beneficiary, which means that while this person may have had a daughter and grandkids and had a relationship with those, all of a sudden there's a will and they're leaving the property to a healthcare provider that they just met maybe 8 months early. So those are usually big red flags, and we definitely are going to get in and challenge those type of wills. The other two grounds that people ask about but are less common and a little bit more difficult to prove are fraud and forgery. So I often get people to say, this isn't my loved one's signature. And those are difficult cases to prove, especially later in life. And if it's meant to be your signature, you wanted to write an X, and folks can attest to that you actually signed it that way, then that would be sufficient. And so to say that a particular signature on a particular date isn't that of the testator is often difficult to prove. And if you do have a situation where there is a forgery, there's usually going to be other grounds, other issues with the will as well that are easier to prove and less challenging. And the same goes for fraud. But when we see a will, we not only look at the will, we look at the entire circumstances of the signing and execution of the will. And we engage in that 6-month discovery process to get documents, get information, so we can piece together everything that needs to be put together in order to either successfully contest or successfully defend the will. The last thing I will say, if you are looking to contest the will, you have to be mindful of the fact that you're starting a process that is likely to last 12 to 18 months or more. So you may want to consider obtaining temporary letters of administration so that during the time that the will contest is pending, someone, either yourself or someone else or the county administrator, has access to the estate to make sure that bills are being paid, lawn and maintenance are being kept up, mortgages paid, taxes paid, and that the property is being preserved and not being deteriorated during the process.